И презентация тоже готова, да, к старту?
Good morning, dear colleagues, dear participants to the conference. Today we have the third and closing day of our event, and it is going to be dedicated to competition, transboundary markets, and antitrust regulation. Traditionally, the annual Eurasian Economic Union Court conference makes it an objective to decide important enforcement issues within the context of Eurasian economic integration. It acts as a platform for discussion, opinions exchange, expertise exchange. The topic of the conference, new challenges, legal dimension, it reflects the processes that have impacted all the integration processes. One of the challenges basically caused our conference to be held online. However, this will not be in the way of our activities, so this will make it as efficient as otherwise. However, honestly, with many speakers, many moderators, of this session in particular, I would definitely find more pleasure in meeting them offline. So today we'll be talking about antitrust regulation and competition. Points up for discussion range quite broadly. It's not just limited to the things about the voice, but these are the primary points for me. Defining geographic and product borders, boundaries of the market, issuing by the Commission of warnings and cautions to economic operators, assessing competition as a result of domestic market protection measures implementation, and interaction of the Commission and antitrust bodies of the state members. Some of the points I voiced, particularly the first one, defining product and geographic boundaries, criteria of determination of transboundary nature of the market, are related to the most recent judgment when the Russian and Kazakh economic operators contested with each other the competition in the transboundary market. Partially, the institution of issuing warnings and cautions to economic operators that has been tried and true in member states is new for the Union as a whole. In my opinion, should the economic operators be compliant with the warnings and the cautions they receive, the competition will be ensured in even more efficient manner. There will be elimination of negative impact on the competition, which will free the workload of the Eurasian Economic Commission to investigate. Unfortunately, something is wrong with the sound. I'm getting echo of the speaker, and it creates prerequisites of the faster attaining the objectives of the Eurasian Economic Union as a bloc. Just a reminder for our speakers, up to 10 minutes time frame for a presentation. We have 20 minutes at the end of the session for the discussion. If necessary, we can use the 20-minute discussion reserve to add 1 or 2 minutes to the speakers' time limits, should there be such necessity if speakers want extension. So we are prepared to sacrifice some discussion time to accommodate the needs of our speakers. So please send the questions to our Telegram bot. My assistants will pass them on to me, and we will voice them. We will see how we're doing on time. It will be either at the end of the session, when we are summarizing, possibly. So that's one of the options. I wish all of us a fruitful working day, and I suggest we get started. The first person to take the floor is Arman Shakaliev, member of the board, Minister in charge of competition and antitrust regulation, Eurasian Economic Commission. His talk is entitled "Current Issues in Protecting Competition on the EAEU Single Market." Arman, good morning, you have the floor. Thank you, dear Denis. Regardless of the challenging situation, you're completely right. we would really appreciate the opportunity to meet and talk to the colleagues offline. However, our today's format is conceptually different from something we've seen before. The objectives of the conference have been voiced. Before I start, I would like to thank the organizers for inviting me to participate in this conference, because our event is important from the viewpoint of searching and identifying decisions, or solutions rather, which decisions are to be taken to create proper antitrust regulation and competition. As you're aware, EEC has been doing competition and antitrust regulation matters since May last year. This is not too much of a time frame, but certain enforcement practices, certain investigation practices have been completed. 10 cases have been considered, 11 cases investigated. The 2020 pipeline includes 23 applications from economic operators. This goes to suggest that economic operators and other stakeholders use this mechanism actively. Also, the enforcement of the court in applying competition in transboundary markets also deserves attention. As you've mentioned, one case contesting the Commission's decision has been considered. Also, the Court has provided 3 advisory opinions. I am convinced that our tight interaction, the Commission and the Court of the Union, on matters of competition will positively will have a positive effect on the efficiency of the Commission. Can you please bring my slides on? I would like to share the goals and implementation mechanisms that we have in the midterm. So next slide, please. The relevant matter of competition protection that we intend to implement with close cooperation with antitrust body of member states will be geared towards 4 main directions. First and foremost, our attention will be focused on the development of the institutional environment to protect competition in the cross-border markets of the EAEU. This will allow maintaining a balance of interests of the EAEU countries and economic entities, as well as creating conditions for the development of competition in transboundary markets. The second, no less important area, is providing direct communication with the business. We consider this direction as a source of information, business requests, and accordingly the basis for a barrier-free and competitive environment. So definitely, this is not just a source of data. This is also something that underpins barrier-free competitive environment in the market of the bloc. The third area concerns issues of ensuring competitive conditions in public procurement, state procurement. The capacity of the EAEU market is assessed at over $120 billion. And definitely creating transparent rules of play will create incentives for appropriate trade, for proper trade, and increase localization opportunities for import substitution. Fourthly, we're talking about the increasing of level of trust and recognition of the Eurasian Economic Union in the international arena. This direction ensures the involvement of the Commission in the global processes of the development of competition, synchronizing the development of the EAEU law with the global trends. Next slide, please. Within the first direction, we have developed a special pathway of actions. It includes a sequence of rapid market assessments, monitoring legislative acts, assessing the state of competition and a number of other activities. As an outcome of this work, the key objectives, as you have pointed out, initially would be ensuring competition and suppressing, preventing violations, identifying red zones, red areas that toughen entrance to the markets. We believe this to be the proper institutional development direction to protect competition in the cross-border markets. We believe this also to be one of the key areas of the Eurasian Economic Commission's work in the near future. We've identified the so-called red areas to which our attention will be focused. Clearly, the entire scope of Commission's activity is geared towards removal of barriers to the movement of goods. Opportunities are created for goods to access markets, competition is intensifying, At the same time, the expansion of the range must correspond to the quality of the goods. Dear colleagues, we're online. There's been a minor technical glitch. We can hear you. Please go ahead. Right. So in this case, we're talking about the so-called surrogate goods. You know that this topic is gaining more and more importance because these surrogate goods represented in our markets, in our partners' markets of multinational surrogate products by multinational companies, they are considerably significantly different from the things or from goods represented in our markets. The ingredients of such goods, if they are positioned as high quality and original, must be identical to the recipe or to the ingredients of Western manufacturers. Our consumers must be informed about the difference, if there are any. The volume of sales of such surrogate goods in the Eurasian Economic Union markets, according to experts' evaluation, reaches as high as $600 million per annum. We intend to comprehensively approach the solution of this problem of leveling quality and ensuring conscientious behavior in the markets, together with the bloc's Technical Regulation Commission. I think that in terms of these matters, we will consider with the states the possibility of empowering the EEC with respect to launching investigations to entities of third countries. This is a very relevant topic. It's a challenging question nonetheless. Nonetheless, the discussion must be initiated. An important aspect of our activity is related to the growing role of digitization in the world. The world is going digital. According to the experts' estimates, the digital economy is growing 2.5 times faster than the global GDP otherwise, and by 2025 it may reach 23% of global GDP. At the same time, the pandemic has accelerated the digitization many times over. The role of the internet and digital giants is growing. They don't just sell goods and services, they actually shape consumer preferences. They create special conditions or incentives so that people switch to this clip thinking, and the selection of goods is happening automatically. Eliminating antitrust, anti-competitive practices in markets in the digital economy is also an important objective. To begin with, we wish to consider several cases. First of all, it's active use of geo-blocking. That is, blocking the use of digital services depending on the territory of the user's location. In our opinion, and this opinion is based on international practice, geo-blocking infringes on the interests of consumers and can be viewed as an anti-competitive practice. Special attention should be paid to internet search algorithms. We intend to evaluate the set of filters used by search engines as to how fair and transparent they are. It is assumed that such algorithms, talking the talk, the IT talk, there is a term, sorcerers or wizards, that enable search engines to manipulate search results and provide more favorable positions to their own services, the services provided by search engine company. This, in turn, adversely affects the standing of independent services in the market. As for the applied nature, we have studied the violations patterns in global giants' behavior. We are completing development of the guideline, which is aimed at considering violations in digital markets. We plan to suggest or we plan to put this guideline draft on the table. It's a draft so far to be discussed by our regional colleagues. As an outcome, we will have a finite document that will regulate and ensure the understanding, the boundaries of behavior, what kind of behavior by multinational companies is off limits. Another important direction is the assessment of impact of protective measures, potential impact of protective measures against third countries on competition. It's quite actively used by the Commission. This power is vested into it by an Annex 8 to the EAEU Treaty. This is improving the competition in the market. Sometimes when protective measures are introduced, the interests of all market participants are not always fully taken into account. Therefore, we're looking into issuing behavioral recommendations to market participants in order to balance their interests, to balance the interests of producers and consumers. Again, it is safe to say that this mild, soft regulation to a certain extent will help prevent potential violations. Dear colleagues, I will reiterate that the important part of our activities, ensuring direct communication with the business, is the foundation to create a competitive environment and shaping the barrier-free environment in the Eurasian Economic Union. Slide number 9, please. The thing is, in addition to rights and obligations, businesses must also develop a so-called pro-competitive consciousness. In this case, it's very important for us to be present and to get feedback online. In the online format, events will be held at which businesses will be able to receive not only explanations on the current EAEU legal norms, but also ask questions on pressing topics. The next slide identifies the importance of pro-competitive behavior instilled among businesses. Compliance benefits both businesses and government. It's essentially, in general, it's an internal audit system for compliance with requirements of supranational antitrust legislation. We're also looking at standardization of compliance through management systems, through risk management system. This is a brand new approach. The benefits it entails are that the compliance, the methodology behind compliance will be unified. At least we will try to unify it, to harmonize it. There are certain approaches when doing so, and there will be clear understanding of the rules of play for economic operators, for entrepreneurial entities when this tool is deployed. Similar mechanisms are intended to be used for retail chains. Back in 2019, our bloc held, and that's an important initiative I would like to highlight, there was a number of off-site meetings of the so-called public reception office, where we talked to businesses. One of the main business issues was the matters providing suppliers with access chains on fair terms. We plan to develop a code of good practice or a code of conduct for retail chains, possibly not in the form of an act or by the Commission. It could be a memorandum within the EAEU Business Council. In any way, this will be a guiding document of recommendation of nature. It will have a reputation effect for commercial chains, creating additional conditions to shape that pro-competitive mindset. The experience of applying such documents exists both globally and in individual EAEU members, particularly Russia or Kazakhstan, so no reinventing the wheel there. Another important objective is digitizing governance processes, the so-called common process. We are completing the technological designing phase. Next year we will pilot test this common process. What will it enable us to do? We will be able, the economic operators will be able to follow online the status of consideration of their application. There will be an online reception, mechanism will be launched. Again, the applicants will be able to track the status of their application. Colleagues, we're having some interference with the sound, so if you can hear me all right. No, it's fine, the audibility is fine. Please continue. Okay, thank you for the feedback. The next slide is about competitive conditions, competitive environment in public or state procurement. Together with member states, we've developed a fairly serious document. We've held a number of consultations on determining the country of origin. A list of production and technological operations has also been compiled. The requirements will apply to a broad range of industrial products, machine tool building, electrical, cable industry, and so on and so forth. The document pursues several objectives. However, the key one is equal access to public procurement in our countries, regardless of which country of the Union, regardless of the country of origin of the producer within the EAEU member states. The final slide, I'll try to be brief. Our activity in the global arena. In 2021, the OECD will conduct a review of competition law and policy in the Eurasian Economic Union. We hope to both receive high-quality recommendations from international experts and also reach a new level of interaction with the OECD and its stakeholders. Another initiative of the EEC in the international arena is geared towards working with regional organizations with supranational powers. We plan to hold a number of meetings on the premises, on the basis of UNCTAD, to hold, among other things, joint investigations. Dear conference participants, once again, I'm convinced that the Commission's activities in the field of competition protection and antitrust regulation will become the basis to boost the level of interest of states in the development of integration processes. The activities of the court ensure high efficiency of enforcement of the Eurasian law. It will help synergize our efforts for the benefit of the Eurasian Economic Union to ensure not just fair market competition environment, fair market environments, but also to improve the well-being of the population of our countries. Thank you very much for your attention. Thank you very much, Arman. A very content-rich presentation. In this respect, I would like to remember the following. The Kazakh side has been traditionally spearheading the activities of the EEC, activities for antitrust and competitive regulation, competition regulation. And from day one, we've had very nice business relations with Mr. Adebergenov, Mr. Zhirmangarin, who replaced him. We also met in conferences. We've had very pleasant cooperation history. So, Arman, hopefully at some point when the pandemic is over, we will meet offline, face-to-face, and some other conference, and we'll discuss the things, the challenges that we see. We will discuss your take on these challenges. So basically, this will be an exchange of experience and discussion. Thank you very much for the content-rich presentation. We're moving forward. The next person to take the floor would be Serik Zhirmangarin, He used to be the member of the board, minister, Sadiq. He used to be the minister in charge of competition and antitrust regulation. Now he's in charge of the Kazakh Competition Protection Agency. It's not a new face for us. We've known him for a while now. Sadiq, you have the floor. We're pleased to see you.
Thanks very much indeed. First of all, I'd like to express my sincere gratitude to organizers of the conference. I see at least Venera represented the court. To me, it's a great honor to attend the conference and participate in the activities of the forum. Well, since the time is short, I will be sticking to business. So I'll be talking about two challenges that we are faced today, and the most important is we need to establish relations with the civil society. And then role of anti-monopoly bodies cannot be diminished. Well, first of all, it's related to the fact that, well, actually, protection of competition, it's the benefit for the countries, for the parties. So through the chain of interactions related to improvement of the functioning of the market, introduction of innovations, technical progress, and in the long run, satisfaction of various needs. In this respect, first of all, at present, we see not the antitrust regulation, which is, in general, following the principle ex post. Then we speak about regulation which is related to protection of competition, development and improvement of competition. That would be better ex ante. So the one which is be focused. So this policy of anti-monopoly body of Kazakhstan. So we are developing the draft of the head of the state, of the decree of the head of the state. The competitive policy would be part and parcel of the anti-monopoly. The government, the parliament, the Supreme Court, the prosecutor's office, all state authorities, local executive bodies, and quasi-state structures. At the same time, we are developing the national draft that would include, at present, they are having 22 working groups that are determining, as I refer them as reference, or the point of tension that are preventing the sector from proper development. And I believe this would be exactly the objectives that we'll have to face or achieve in the nearest 5 years. So the improvement of these indicators would mean and refer relieving of certain barriers of entering the market, and this is the only, I believe, the appropriate interpretation of the fact that what the competition basically is. And then within the framework of this national project, we are opening. We have created a number of forum for the outsourcing. So on a everyday basis on open space, we are discussing the most burning issues and most interesting issues. So we have already discussed the issues of approach of the airports, so that COVID aspects, PCR, personal protective tools, medications, telecommunication services. So all costs have been evaluated. In this respect, a lot of assistance is rendered by experts which actively participate in this kind of sessions. And the most important forum that we have created, according to the Council on Barriers, related to the entrance of commodity markets. So we have 17 regions, we have councils that have included 12 representatives, I mean high-level professionals dealing with different directions of business activities, well-known people, well-known persons. One of them is heading the council. Well, at least once a month, these councils would gather, and then they would be discussing important issues like barriers, following a certain methodology based on proposals. They would be submitting us for further approval. And I believe that this would be improving the activity on relieving the barriers, and would promote development of civil society. Understanding and perception that competition would be working not for the benefit of one state. At present, it's becoming more and more important for the space of the Union. Since we have been talking a number of times, well, people at the territory of the country of the space have having more and more trust to the bodies of the Union, while at the same time there's a lot of criticism voiced. So what Arman was mentioning, so new directions of activity, continuation of the previously, so openness of the policy of the promotion of competition. I believe there should be at least 50% of attention paid, time spent, and then actively interacting with civil society, first of all with business community. This is kind of basic part of the activities, and then anti-monopoly bodies in Kazakhstan have opened their activities. So in this respect, for the state officials, we have more troubles because we are plied with criticism, but at least criticism is not related to the fact that we are not acting anything. So we have reduced the cost of PCR tests without applying any antitrust regulations or any tools of regulation. 2 times the cost of masks have been reduced, and then we're actively decreasing the prices for medications for the COVID, say the so-called COVID base of COVID list of medications. We are actively working in other directions. What are we concerned with? As an anti-monopoly body, we have to look forward. Well, there is a methodology of regulation in the world, so it says no casting. It says it looks at the nearest future, the past, the current, and the nearest future, in order to determine the trends, and based on these trends to develop certain policy. Well, roughly speaking, you all are aware of this. If the person starts buying certain medications 2 months, then if people are actively buying this, then epidemic is underway. Digitization processes are underway for quite a while. And there are threats related to the fact that the digital economy is advancing and is quite active, is taking plenty of our time, a lot of our time. Apologize, the kind of refurbishment facilities, the extra sounds, we will do our best to pacify these people. Second issue, the anti-monopoly body doesn't seem to have appropriate tools. With violation of in the sphere of digital technology, we actually did not notice any of this. I'm welcoming the fact that the Commission develops guidelines. At least these guidelines would be defining the directions of activity and would be a new signal, a new impetus. At present, there are threats of changes related to digital inequality. Digital inequality is, first of all, in the sphere of knowledge, in the sphere of access to knowledge in the digital technologies. I'm talking about business, I'm talking about population. Gradually, we're becoming digital plankton of the whole world, of the rest of the world. In this respect, certainly, say, we don't have any other types of protection rather than monopoly, anti-monopoly protection. So there's basically no tools. And concern is expressed that plenty of bodies, they don't have basic understanding what they have to do. Second issue, the digital platforms establish or ensure control of the consumer's behavior. You're aware that we pay, so there are no free of charge services or just free lunch, so we are paying with our personal data. This data contains certain specific features, characteristics. In previous days, this was referred to as 3V, volume, variety, velocity. So the fourth V is added, it's value. Value of the data that is arising because of the activities and the processing. Processed data become the driving force of the scientific progress as well as the trade. In this respect, of course, the people who are possessing data, they keep network effects or maintain. There's a law on, so the usefulness of the platform is proportional to its square root of the value. So I'm talking about Yandex in Russia. Well, basically, there are no other platforms that we could interact to the extra dominance of the world platform. They don't exist, simply. So we have been mentioning this a number of times, this type of problem. Well, inter alia, these network effects might result in closure of the consumer at a certain level. and to a certain extent may affect the competition. I'm not going to spend time on this issue. There's a lot of violations, a lot of abuses in this respect are taking place. So these are the approaches to regulation that we could use, and well, we would not be able to act normally working at digital markets, determine the behavior, because hypothetical monopoly test, SSN IP test, small, not transitory, increasing of price. So, but it's insignificant but considerable increase of price, because we don't have the price at all. Most of the services are offered free of charge. Geographical borders, based on the fact there are limit of transportation, for example, costs, or dubbing the service. Say then, for example, making another song, then geographical borders become global. In this respect, it's quite difficult to counteract, to work. The Commission has conducted a research, and there is a very interesting reference to the law of Germany. The Germans, in their competition law, or competition act, presence or allowance of the market presence should not be read due to the fact that commodity or service is offered free. So they also consider free of charge offer of service or goods as market. There are options, there are similar tests. CCN, DQ, decreasing of quality. The way attitude of user to a certain platform might change if the quality of service offered by the platform would go down. It's difficult to determine qualitative parameters. Certainly, this all affects the way how the criteria of nomination are defined. The share of market that we determine as the volume of sales at present cannot be significant, or may be insignificant. In 2009, telephones, BlackBerry phones have been occupying 20% of the market, so they disappeared. So the Android and iOS, so they're basically taking the largest lion's share of the market. It was mid-term perspective that it happened. So we speak about quality domination, and then there arises real and potential competition. So the giants, digital giants, they simply destroyed competitors at faraway distances. They're simply merging or protective leverage. From the other hand, innovation is also developed so that to be procured, to be bought, basically speaking. So innovator is working so that one is spending money to buy. In this case, merger at present should be evaluated following certain principles. What kind of impact this may refer to innovation? What would happen with big data? What would be the model of relevant market we are looking at? What kind of business processes take place there? Because not necessarily always the combination of the buyer and the seller works. Not necessarily it's one-sidedness or two-sidedness, multifacetedness could be in place. So at present we have concern that these large platforms, they are attacking the traditional markets. Amazon is not only just a mediation platform, at market of sales of books, of many other items, basically they are sellers. They are competing with sellers of books. So in this case, these are the objectives that we'll have to deal with, the tasks we have to answer. We are going to enter the parliament with package of changes that would create, also relate to digital issues, digital sphere. We are drafting some suggestions, some offers that would create no doubts on the part of anyone, so that would have been accepted without any doubts. But tomorrow would enable us and offer us instruments of impacting on behavior of digital platforms. Well, the objective remains one and the same: anti-monopoly bodies. That would include supranational anti-monopoly bodies should become the gatekeeper on the way of illegitimate practices in the sphere of digital development. At the same time, they have to be absolutely transparent on the way of innovations that would be useful for the market and should not become an obstacle to the way of technological progress. I presume that at present that we are aware that how the global markets are working. So international UNCTAD, basic topic would be the competition. The cartels are of interest to our colleagues. The interaction of anti-monopoly bodies. There is no alternative to international cooperation in the sphere of anti-monopoly bodies, because I've mentioned already the product per se is not defined, is not determined. Geographical borders disappear, they are of global nature. Without global cooperation, it's impossible to fight these cartels and giants. Certainly in this respect, the importance of our union, an economic union, we have supranational bodies. It's difficult to overestimate or underestimate. This is there has been good foresight that we have created it, and it's an opportunity to counteract and to compete during this market. During 5 nearest years, there would be most agenda of the national anti-monopoly arena would be digital markets and impact of digital markets. We will be supporting your man. Once again, thank you very, very much. Thanks for the organizers of the conference for the opportunity to take the floor today. Thanks very much and all the best. Thank you, Sirik. As always, very interesting and comprehensive presentation. You were absolutely right saying that cooperation of the competitive anti-monopoly bodies with the Commission and between themselves would be a good contribution to protect competition at Eurasian space, at trans-boundary markets. And certainly, if it's impossible to mention that competition at present became, if we speak about the EU language, one of the pillars of our integration, then we are on the right track, on the right way, and it would become part of the integration would become the pillar of it. So it was absolutely right, the issues of digitization and big data, digital economy in the sphere of economics and the sphere of digital competition. So we are interested in the approach of the Republic of Belarus to this issue. Next, the floor is offered to Ivan Veznovets, First Deputy Minister of Anti-Monopoly Regulation and Trade of the Republic of Belarus. So the topic is improvement of the protection of competition at the transboundary markets. Ivan, are you with us?
Yes, good morning. I can hear you. Please, you have the floor. Thank you, Denis. Dear colleagues, it's a pleasure to see you all in good health, albeit in online format. I'm pleased to see you nonetheless. We hope that you're doing well. We thank for the opportunity to talk to the organizers. We're very happy to thank the organizers because of this possibility granted to us to talk, well, not offline, but online. It's a great thing. In my talk, I would like to dwell on the practical aspects of the operation of antitrust body and interaction with the EEC. I would also identify the principal directions and pain points, bottlenecks that we've seen over this brief course of time. Eurasian Economic Union is developing incrementally, and we gradually build up an array of powers for the EEC when applying single competition rules within the EAEU territory. We should recognize that each country and the Eurasian Economic Commission as a whole is facing particular problems, particular challenges, defending domestic markets of each member state of the Union, and with appropriate development of competition, and respecting the interests of all stakeholders, not just the one country in question. To reach these goals, it is paramount to build a system to monitor compliance with competition rules within the EAEU bloc. A two-tier control system has been defined. First of all, this is the controls at the national level, where we have full powers as an antitrust competition authority, and our colleagues in the other countries, and the supranational level, the EEC. This two-tier system, or two-level system, there is no way that challenges would not arise, and the matters of determining the competence or delineating the competence. So there are several topics and several points to be discussed and adjusted the way we see it. First of all, we need to separate the competence of the national member states antitrust bodies and the EEC. To us, recently, of relevance is the matter of considering the market as transboundary, cross-border. So there are several messages to support that. First of all, we need to separate cross-border markets and domestic markets of member states for antitrust competition and abuse of dominance. As for the indecent competition or unfair competition, more like it, our treaty says that we're supposed to monitor adverse impact on competition or against competition on the territory of two or more states. At the same time, the geographic markets of the country, the geographic boundaries of the market must also span over two or more countries. However, in our legislation, in the pro-competition legislation of the Union, there is a lack of clear definition. How do we distinguish or how do we delineate and separate the actions of competitors in these two markets? So technically, the competitors must be registered in two different countries. In that case, the markets where they engage with each other, where they work, will be deemed cross-border. But how do we interpret the actions of the company headquartered in one state and its actions are affecting the competitor in another state, in another country? Is that the cross-border market? Can it be considered within the framework of the Eurasian Economic Community as such? Or this impact is only limited to the member states' borders, and this basically means that it is the national antitrust competition enforcement body that needs to handle that. So there is a practical issue related with this. Another aspect in terms of delineating competence is the matters of abuse of dominance. The Union law lists abuse of dominance, or the dominance is defined as market share of 35% in member states. However, realizing the scale of the market and the scale of the companies, the question is, can we consider the dominance 35% of all 5 markets combined? Or are we supposed to calculate this market share individually in each member state? Because situations arise sometimes when the transboundary or cross-border market share is assessed at over 35%. However, the market share in every particular, or for example, say provisionally, one company has a market share in one state of 50% and 15% in another state. Is that abuse of dominance, or is that dominance in the cross-border market? So again, from our viewpoint, this matter requires additional discussion and possibly fixing. Next aspect, and I would like to support Serik's position, when assessing dominance in the cross-border market, we need to digress from quantitative parameters. Well, maybe not digress, but to throw quality on top of that and consider them as a whole. because so that we could clearly understand that not only the market share can affect the behavior of the economic operator and affect its competitive behavior in the cross-border market. The next point I would like to raise, particularly with respect to the interaction of national antitrust bodies and the Eurasian Economic Commission, is the regulation of natural monopolies and shared markets activities. This matter is also related to the notion of transboundary market, and the definition or defining whether shared markets in which are natural monopoly operators work, are they cross-border or not? Currently, the appropriate legislation is being shaped to determine this. It deals with the domain of natural monopolies. So can we consider them as cross-border markets from the viewpoint of antitrust regulation? Or, taking into account that the appropriate legislation will be shaped for the single market, will these natural monopolies be regulated by antitrust law then? Again, quite a number of issues, if not exist, but they will arise, especially with respect to law enforcement. So the interpretation of the notion of single market and its relation to cross-border market. We believe that that issue requires additional discussion and consideration when drafting the appropriate legislation. Another point I wish to raise, and to a certain extent support Armand's points, is anti-dumping investigation, launching these. Indeed, certain progress in terms of accounting, in terms of considering the competition-related matters, has already been reached, particularly the conclusions as to the impact on the competition of anti-dumping investigation and appropriate measures. These are felt. They are attached to the case. For a number of goods, there are prevention measures taken, price monitoring after anti-dumping measures have been taken, following the adoption of anti-dumping measures. In practice, we also see that it is not always that the conclusions on adverse state of competition are taken into account. Unfortunately, this is the case when the anti-dumping measures are being adopted. The second aspect, when anti-dumping measures are in place, are set up, and we see, following the monitoring, that it worsened the competition and boosted prices, caused the spike in prices and even shortage of product or goods in the market, then reconsideration of anti-dumping measures is not always done again, and the matters of competition are overlooked. We believe this topic deserves more closer attention and more stringent approach from the viewpoint of antitrust legislation, as well as taking into consideration of all the stakeholders' interests, first and foremost the consumers' interests, when adopting anti-dumping measures. Right, so there's another question that I wish to identify, is the interaction between the EEC and antitrust agencies of respected member states for antitrust investigations. This year's pandemic has definitely changed this paradigm completely. The interaction of everybody, every agency out there, between them. So the way we see it, antitrust agencies should develop new approaches interacting with their colleagues, on how to interact with their colleagues. We are now working to establish joint processes. However, this work does not include one very important point: exchange of confidential classified material and exchange of case circumstances that are again of classified nature. So there is a problem these days, indeed, respecting the time frames or respecting the deadlines for the antitrust case consideration and the interaction of antitrust bodies, because oftentimes we simply lack the possibility to obtain the data, first and foremost the classified data from our colleagues. So we wish to suggest within the formation of these processes, we wish to suggest creation of a channel for data communication, for classified data communication, particularly so as to accelerate the consideration of antitrust cases. And the last point I wish to raise, in a nutshell, the prospects and current work being done to prevent violations by entities from third countries. It's a bit of a debatable question indeed. We have been raising it and discussing it at every platform out there. The way we figure it is necessary to consider this question, to consider this matter, take into account the powers of national antitrust bodies, and we need to accommodate those powers with the suggested amendments of the EEC's mandate. Because indeed the actions of third country entities are supposed to be assessed from the viewpoint or through the prism of antitrust regulation. The biggest point is, again, delineating competition, so that we know when we're dealing with a national market, a domestic market, or a cross-border market. Accordingly, for the domestic agency or for the EEC to get involved with. So these are the points that, by and large, require discussion, exchange of opinions, and to a certain extent, amending the legislation and possibly amending the treaty on the EAEU. Thank you very much again for the opportunity to speak, to identify the pain points that we have been working on over the past time frame, and we're prepared to continue this discussion. Thank you so much for your attention. Thank you, Ivan. We're pleased to see Olga there, to welcome her. She was also there next to you during the presentation. Possibly she will take part in this discussion afterwards. Yes, you have correctly pointed out that sometimes imposing of anti-dumping levies or duties is not always pro-competitive, or does not always take pro-competition into account. Unfortunately, this experience of anti-dumping duties has lacked positivity, let me put it this way. It didn't just cause a price spike in certain products. These products became short. There was a shortage of these products in the EAEU market. So the practice of imposing anti-dumping duties to boost competition, well, we need to be very careful there. The next person to take the floor is Alexei Sushkevich. Alexei, we're pleased to welcome you. He's the director of the Department for Antitrust Regulation in the EEC. The declared topic of the talk is current issues in the application of EAEU law for the purposes of protecting competition in transboundary markets.
Good afternoon, Denis. It's a great honor to take part in the conference for me. I took part in the first and second and then subsequent conferences, and was witnessing that conferences of the Court of EAEU are acquiring international importance, becoming important, really bright activity on the agenda of each anti-monopoly specialist. So thank you for allowing to discuss issues in specific section. It improves discipline in discussion, and we are aware that would be people listening to us, very interesting experts. So judges of international courts, and the level of discussion and the level would be improving, becoming higher and higher, and accordingly meets the challenges that we are faced with. My presentation is dedicated to the facts and problems that we are faced with at anti-monopoly body, Eurasian Economic Commission, in sphere of application of law, because Department of Anti-Monopoly Regulation ensures this direction of activity of the Commission. I will tell you about statements, investigations, cases that we went out of the borders of routine or limits of routine. So we were forced to switch to to resolve issues of general nature. What kind of general nature issues that, in our view, just should find its solution in this sphere of competition law of the Eurasian Economic Union. So I'm going to share my screen, and I would start and launch presentation. Respected colleagues, could you see your presentation? Not for the time being. It should be for the whole screen. No, we don't. Dennis, could you see? We see you clearly. Thank you, but it's not the stuff I wanted to show you. So I'm going to share my screen. Yes, share. What about now? Not yet, unfortunately. Yes, that's it. So I'm very pleased that it works. So it should occupy the whole screen. So the important issues of application of law of EAEU in order to protect competition at the common market of the Union. Armen already mentioned the issues of statistics of 2020. Indeed, we have received, or at least we are working with 23 applications. So we have adopted the procedure as we soft regulation, as we refer it. So it's issuing a warning that potential violator of competition at the market would be reinstated, whereas application would be recalled as private dispute has been resolved within the framework of the Commission. So we have conducted 11 investigations and we consider 10 cases. Let me stop and then let me deal not with all aspects, but most important. So which are developing the practice of activities. So in 2010, the first case, the most important case, then the case that resulted in Kentau transformator plan, complaining basically the only producer of transformer steel at the Eurasian economic space. It's Novolipetsk Metal Works, in understanding of Kentau. This has been discriminating users of the Eurasys that have not been registered, say that they're not speaking non-Russian consumers of transformer steel. The Kentau transformer plant considered the case, collegium, high chamber, so the 130 decision was taken, that indeed stated the fact of abuse of the dominating powers by the group of officials of the Novolipetsk Metal Works, applied appropriate sanctions, and then listed the activities that should be made by the officials of the Novolipetsk Metal Works to eliminate discrimination of consumers from Kazakhstan and Belarus. 130th decision was reconsidered as any decision by the Council of the Commission, as the was unanimous decision was not adopted to reconsider. So this decision 130 was considered by interstate council, and then unanimity was not achieved whether this should be repealed or recognized or just remain in force. However, the Interstate Council was wiser, pushed the Commission to develop the procedure of the so-called soft regulation, so procedure of resolving dispute and restoring the competition without application of sanction to potential violator or perpetrator. If the proposal offered by the Commission is executed, the application is recalled, and then dispute is resolved, competition is restored. This process is attended by all 5 anti-monopoly bodies of the member states, the Commission, the applicant, and potential violator. So the second application of Kentau transformer plant was subject to this procedure. An LMK developed, according to the proposal of the Commission, the trade and market policy that would be regulating the whole range of issues of marketing transformer steel, that would eliminate any discrimination of potential consumers and users outside the Russian Federation. And roughly speaking, implementation of the proposal resulted in stating that the dispute following the first and second applications of the Kentau transformer plant, complaining about actions of an LMK, have been resolved. That enabled Interstate Council, as back as July 2020, to come back to consideration of the proposal of the Russian Federation to revoke the decisions of the Commission and adopt the following decision. Interstate Council took into account the information about full implementation by public limited company, LMK, of the trade and market policy that has been developed following the proposal of the Eurasian Economic Commission. Having recognized the issue on elimination of principle of violation of general rules of competition, Interstate Council signed the Commission to consider the nearest session to stop the consideration of the case about the violation of rules of competition at transboundary market, and then having lost and without any legal consequences the decision 130 on the first case in relation to Novolipisk Metal Works. The Chamber of the Commission reconsidered the issue about decision 130, dated 26 September 2017, and on the 11th of August has recognized that decision was void and having no legal consequences, which, roughly speaking, exhausted the dispute and restored competition completely. The market of transformer and isotropic steel functions based on competitions, which is the most important achievement, I would say, of the bodies of the Union. So, thanks God we did not went as high as the Council of the Union. So the court, other bodies, we were approaching everyone, because arguing in the court of the decision that was not enforced, 130th, putting together all efforts that resulted in restoring of the competition. So, in a brief manner, I'm going to touch about two unfair competition of the Russian producer, which is well known to Wimbledon company, that complained about actions of the Nesvizh plant of children's formula, and then complained about the large Russian, which is packing tea, which is well-known brand in the Russian Federation and other brands, Greenfield brand, trademark. Both applications were saying that the competitor, without any approval of the copyright owner, has been using the trade name or trademark, say the image of the form of packaging of the commodity, in order to promote their commodity at the same kind of commodity market where the legal copyright owner functions. Indeed, following the appropriate national rule, the competitor that without any permission making use of the trademark, roughly speaking, would have been considered unfair competition. But we have been facing with the issue of the Eurasian Economic Union, we don't have the common law of the trademarks or intellectual property. So that means Greenfield trademark that is registered in the Russian Federation and all copyright owner in a legitimate way, so they are legitimate owner of the trademark. So Arimi, limited liability company, similar trademark was registered in Kazakhstan by one of the Kazakh company that was making commodity with similar trademark. A similar situation with Nesvizh, with dairy products of the large Russian producer and the Belarusian producer. So these are roughly the problems and troubles that we are facing with and has to deal with. As a restorative measure, the measures aimed at restoring competition, the Commission is not entitled to issue warning and then approach the registration body that has been registering to recall the registration. So this was done, for example, in the Russian Federation. In our case, we have very good established procedure, and I hope this would be functioning, the mechanism of the soft regulation. Within the framework of issuing proposals by the Commission and its implementation or execution, the participants of the dispute, parties to the dispute, it would be better to stay at the market, to live in a peaceful manner and allow each other market, rather than continue this kind of disputable relations and lose the share of the market. Next application that we have been looking at considering, and is causing the issues and problems of similar. This again, Nur Sultan is procuring the liquidized gas in Ekaterinburg that is produced by one of the Gazprom holding companies. Liquidized gas, which is transported from Ekaterinburg by their own transportation facilities, global gas regasification, so it's released to the pipeline of Nur Sultan to use as fuel. The issue we have been facing while reconsidering this application, when we started consideration of the case, draft of the proposal, we have been faced that member states have considerably different perception on a possible spreading of the general rules of competition to the sphere of turnover of such commodity as liquefied natural gas. The point of view that exists on the part of this or that member state prevents the jurisdiction commission spreading to aiming at protection of competition at transboundary markets, and prevents this kind of appropriate consideration of the resolution that global gas regasification approached us. Since the sphere of turnover of liquefied natural gas in the transboundary market is outside of the scope of application of the general rules of competition, and powers of the Commission are exhausted solely by monitoring prior to entering the treaty on the use of gas, the turnover of gas. One more investigation. I'm switching to investigation. I'm just over with applications. So this is the international roaming services. So this investigation of the operators of mobile communication. So in the Eurasian Union we have 16 of them. So we see drastic difference price-wise per minute of conversation within the framework of domestic network and minutes in the guest net when the client is on roaming. Take a look at my slide. This difference sometimes 40 to 50 times. This maximum means so the 40 to 50 times difference. So roughly speaking, it's economically impossible for the user, reduces the helpful effect of the telephone communication itself, just making the travel geographically and then considerably toughening the opportunity to travel, creating additional barriers. So we have faced a situation when operators, mobile communication operators, denies the competence of the Commission to consider relations in the case of roaming, as they believe these relations are of no transboundary nature. So they are not a transboundary market, and solely this is national. So these are solely national markets. So the case was considered this cartel case, distributors cartel, Cochlear company that is improving the ability to hear for the people suffering So we established cartel who split the union's market based on the state borders. So we have issued, the chamber of the Commission issued a warning or instruction, and at present we find ourselves at the execution stage. So the improvement of norms is needed, of the law of the Union, in the sphere of voluntary implementation of the decisions of the collegium or the chamber, and forced. So the one should be forced to be implemented by member states. Basically, there are no decisions of the Commission due to the international treaty. There is an executive document themselves. There are certain issues that we have to deal with, the issues of general nature. We will find solution there too. So the case was completed with trading house Kama. We have not established any violations as they adopted the advisory opinion of the Eurasian Economic Court. It's important for the chamber of the Commission that allowed establishing jurisdiction of the Commission to prevent coordination in the sphere of competition, and he unequivocally stated that if parties are part of the vertical agreement, anti-competitive combination cannot take place. This allowed recognizing trading house Kama as having made any violation. So the butter, by misleading the consumer, so Belarusian company suffered, joint stock company Milkovita, the unfair, so the entity in Russia has been marketing counterfeited product, falsified rather than counterfeited. So the fat was presented as if it's butter, having referred to Milkovita. Belarusian producer suffered because of these kind of unfair actions of competitor. So Commission as anti-monopoly regulator have exhausted its powers and tools in order to establish this violator. So certainly this action is definitely punishable. So this ill-natured character. This type of problem is a real one, even though we have mobilized and used all resources. Next small case, one remark. We are considering the case Rezhev cable company, Belkabel actions in perception of Rezhev Kabel works has been distributing the stuff and has been undermining the business reputation and then resulted in loss in the market of cable products. The problem of the Commission is how the actions of the association relate to actions of their members. Association is not a competitor of the Rezhev cable plant. They are not manufacturing or making cables. However, we believe actions of the members of the association may contain the features of the unfair competition. So this is exactly the case that we consider. And the last but not the least I wanted to mention, so this Commission for the first time in December, I hope that the issue is on the agenda. For the first time we are approaching 4 decisions, 4 individual cases on taking to responsibility for failure to provide information following the request of the Commission in the course of investigation, which is very, very important. Without any sanction, any our request to provide information would be having no result. Our interaction with the economic entities would be useless, and there would be no grounds to speak about the result of the investigation. The problems we are faced with this is as follows. National legislation of each of the member states, in terms of administrative liability to fail to provide information following the appropriate request of the appropriate body, has been developed in a very detailed manner. So this is difficult from the procedural point of view, containing a lot of requirements to the request itself and so on. In this respect, the Union legislation contains general wording. It's not sufficiently detailed. We wanted to go on this path to show that all things were done in an appropriate way, following the tough criteria of the national law, taking to liability for failure to provide information. I believe that this kind of result would be achieved by end of this year, by late 2020. So getting out of the sharing, I'm back on the screen.
Возвращаюсь в режим экрана. Так, демонстрация остановлена.
So that's it. My presentation is over. Dennis? So I was supposed to come back to the screen. Yes, Alexei, thank you. We could see you. So that's it I wanted to say about the current issues and consideration and investigations we have been conducting. Thanks, Alexei. We have received some new information. Why we have received about the request about the advisory opinion. Now it's became clearer. So you have elucidated this issue. Well, I'd like to comment the following. Well, first of all, the Novolipetsk Metal Works case, in addition to the soft development, as it seems to me, it became the grounds to be included into strategic directions of activities and development of the strategy 2025, stipulating that decision in the relation to private individuals, which are of normative nature, but in relation to economic entities, should be suspended compared to the regulatory framework that are applicable to the economic entities and states. So it has been reflected, and the issue was dealt with to split between the regulatory and non-regulatory framework applicable to entities and individuals, being an opportunity to having them suspended. And we'll see how this would be practically implemented. In relation to roaming issues, you were absolutely right, touching it. What we would like to is that integration works not only for economic entities, not only for businesses, but for citizens, for natural persons as well. So this issue is exactly what kind of benefits and good things of integration may be felt by natural persons, and this will be positively perceived. So I wish you success in this respect, in this direction. And then coming back on Cochlear, that you referred decision 88, not only you reading our documents, we reading you without approaching the court on this issue. And resolutive part of this decision is much better from the legal and technical point of view, has been worded. There are measures aimed at elimination of violation of competition. So you are improving, we are improving, and it's all correct. So joint activities and cooperation and participation in such conferences give its fruit. Thank you, Alexei. The last presenter of this first part of the section would be Kirill Entin, Deputy Head of the Secretariat of our court. The topic is the law of competition of the EU through practice of the court. Kirill, you're welcome, and the floor is yours.
Hello. Good morning, Dennis. Thank you. Yes, indeed. The development of law and law enforcement practices go hand in hand. They are early on in the stage of their formation. The judicial practice as a tool is supposed to fill up the gaps, fill up the lacunes through the interpretation of the Eurasian law, proceeding from best practices, global practices, and the practices and experience of other integration blocks and their judicial bodies, of course. At the same time, the existing court practices show that pro-competition provisions can play a significant role if the law is properly enforced. This pertains both generic aspects, such as delineating competition authority competencies between national bodies and the Commission, applying the non-bis idem law, as well as nebis in idem law, as well as delineating the national and supranational levels of competition regulation. The first legal act passed by the court, the first judgment must have been meant, the court noted that competition regulation in the EAEU is carried out at two tiers, the national tier and supranational tier. The advisory opinion contained a very important provision. The general competition rules are directly applicable and should be directly applied by member states as rules enshrined in an international treaty. The significance of this conclusion in their advisory opinion lies in the fact that the recognition of the direct effect of the treaty, Article 76 of the treaty to be exact, opens the way for its active use by individuals. So this is the possibility to not just be used by the Economic Commission or by member states. Individuals can also refer to Article 76 of the Treaty on the EAEU, both in domestic courts and the supranational judicial body. Particularly, the court's indication of the direct application of this article is a sort of an instruction to the antitrust bodies of the member states and national courts on the application of this rule, even in absence of relevant provisions of national legislation. Particularly if a behavior violates Article 76 but does not fall under the jurisdiction of the Commission, this is the reason to go to the national antitrust authorities, even if such a provision is lacking from the national legislation. The ne bis in idem point is further developed by the court. The court indicated that the law provided for by the said provisions, the obligation of the member states to apply the EAEU law when suppressing competition violation in their territory does not include a situation in which national legislation contains norms coinciding with the provisions of the treaty, meaning that the domestic law matches the provisions in the supranational treaty, the treaty on the EAEU treaty. So essentially, the expertise accumulated by the European Union in particular, shows that the application of not just domestic law is possible, but if it's within their competition, they can also look at the behaviors of specific economic operators located in other states. Another point I wish to discuss is the discretion. With regard to the discretion of the member states to implement the general rules of competition in national legislation, the legal position of the courts set out in the advisory opinion on vertical agreements case, the court answered that the applicant's question about the right of the member state to establish other criteria for the admissibility of vertical agreements in comparison with those provided for in the Treaty on the Union. The court stated that the EAEU law distinguishes the concepts of admissibility criterion and banning. Admissibility is basically when it's an exclusion from the ban. The court proceeded from the standpoint that the share provided for by the treaty, the product market share less than 20%, is a sort of a safe haven that in every case will rule out imposition of the vertical agreements ban on an economic operator. And the safe haven is not supposed to be jeopardized anyhow by the domestic legislation. Otherwise, there can be a case, or there might be a situation arising, where the level provided for by domestic legislation will be lower than the level of protection by the treaty. In which case, the situation will arise where economic operators from different countries will not enjoy equal opportunities. The same approach is traced from the Regulation 1/2003 Before that, earlier practices also saw this approach be applied. Wolt Wilhelm and Giri and Gerland cases. Alexei has mentioned a case on coordination. The court also shaped important legal positions. So essentially an advisory opinion of the court formulated legal positions to delimitate separate constituents of the conclusion of vertical agreement and the coordination of economic activity that are inadmissible by Article 76 of the treaty. According to this paragraph 6 of Article 76 of the treaty, individuals, commercial entities and non-commercial organizations are prohibited from coordinating economic activities of the member states. The importance of this provision has been talked about by Alexei. I'll just point out within the framework of scientific discussion that even the European Union, where there is no specific article or specific ban on the coordination of economic activity, it also uses the rule, or it arrived at the need to not just hold the associations of producers accountable, because these platforms are sometimes used as ways to coordinate actions, to agree on unfair practices together. But there were practices of the EU against companies like Delta Fina that were operating in the adjacent markets or that were rendering consulting services or brokerage, and they basically colluded and they facilitated the cartel agreement to be implemented. So largely the European law and the Eurasian law are basing on this important principle of efficiency of enforcement. Essentially, the anti-competitive behavior should not be punished not only on the part of those actually perpetrating, but also on the part of those who facilitate and collude to make it possible. Another point is the competence, coordination. In this respect, an important matter has been already mentioned, the points on coordination, where the court refused to link the powers of the Commission to prevent anti-competitive activities and the powers of the Commission to prevent conclusion of vertical agreements. Again, the selection was made proceeding from the viewpoint of maximum efficiency. The powers of the EEC to prevent the violation of overarching competition rules was supposed to be upheld, so that the Commission can launch investigation and punish the coordinators of such unfair practices, even if economic operators are located in the same state, in the same country. Yes, indeed, this approach is not without shortcomings. There can be a case where the principal violation is handled by domestic bodies of the state and the coordination is done by the Commission, or is handled by the Commission, the coordinators. However, the court proceeded from the understanding that such a situation is anyhow better than a lack of dealing, than a legal lacune, where an entity coordinating the economic activity simply by virtue of being in a different state or headquartered in a different country will avoid responsibility. On the other hand, the court also made it a rule to consider this situation from other countries, to look at the situation in which economic operators are in. Then non bis in idem advisory opinions serve best to this. The court pointed out that the same entity cannot be held liable twice for the behavior in the domestic market and at the level of the Eurasian market. So essentially, if the competition law is broken in transboundary markets, then we proceed from whether we should look at the advisory opinion together with the special opinion of Judge Seitimova. We know that the Eurasian consideration is kind of swallowing the violation in the domestic market. In this case, the prevention or the cessation of such unlawful practices will be within the power of the Eurasian Economic Commission. This advisory opinion was discussed at length at the previous session of at the previous conference. Just for the sake of scientific discussion, I will point out that the court is sometimes criticized because, on the one hand, it is looking at what the EU courts are doing. On the other hand, the court is not following this practice to the letter. The non bis in idem, the parity, and the Eurasian court refused from one of the points made by the EU court. We followed the defense attorneys of the European Court of Justice on the one hand. On the other hand, we also followed the practice of the ECHR. So the use of approaches inherent to other courts, the Eurasian Economic Court never simply copy-pastes these practices. There is at all times a procedure of critical contemplation and adaptation of the experience of other courts to the peculiar nature or the peculiar features of the Eurasian Economic Union per se or particular aspects involved. As for the most recent case considered, Zhulumbet Bayeshev, the president of the court, spoke about it during day one of the conference. I will just highlight it is important that the practice of the Eurasian Economic Court is only beginning to take shape. We should not just be looking at the grounds why they deemed the Commission's decision inappropriate. We should also look at other positions that the Court voiced as wishes or voiced in special minority reports of the judges, particularly the legal definition, or the legal certainty, strict adherence of the procedure, of the sequence when dealing with competition violations. I would like to complete my presentation by highlighting the problems that the law enforcement practices have identified initially at the outset. The first issue is the treaty on the EAEU sometimes fails to contain the exhaustive list of prohibitions. Particularly this goes for vertical agreements where, the vertical agreements banned by Article 76 of the treaty do not have the formal ban to divide the markets geographically. Just to compare, the member states have this kind of division in their legislation. The European Union law also features this. So we're talking about the ban, the lack of the ban or exhaustive ban per se. So the question is, can we bypass this gap through interpretation, or can we requalify, recategorize vertical agreements into horizontal agreements? From my viewpoint, this pathway is very risky, especially in the light of our yesterday's discussion about the importance of the legal certainty of principle. Legal certainty principle is paramount so that economic operators would clearly know the aftermath, the consequences of their behavior. And finally, a topic closely related to the one I'm dwelling on right now is the necessity to go towards extraterritoriality, extraterritorial principle of interpretation of Eurasian law. I believe that the current situation where the Eurasian Economic Commission does not have the power to hold an entity responsible, for example, a supplier within a vertical agreement, a supplier of a certain product that dictates or imposes its conditions on the economic operators in the Eurasian Economic Union market, is not to benefit the competition law, so to speak. So there must be a possibility to ensure fair play to not just economic operators within the member states, but also for foreign economic operators. The current situation, again, through the interpretation, we see some ways to hold foreign economic operators accountable, to hold them responsible for violating the EAEU law, but it will be done by national domestic bodies. Hopefully, this opportunity will also be created for the EEC. Thank you very much for your attention. Thank you, Kirill. It's been interesting to hear what you had to say. To complete part one of our session, I wish to say that several questions came in, both to Kirill. Well, he's right here. I mean, he'll have the opportunity to deal with them later. And there are also several questions that have come in to our guests. I'm not sure that they will stay on because of their busy schedule until the end. Sirik Zhumangarin, are you with us? Will you be able to answer the questions that came by telegram? Yes, please. I'm right here. Okay, so the questions to you are these. Is the antitrust body of Kazakhstan planning to amend the national domestic legislation to harmonize the penalties for breaking the antitrust legislation, to harmonize it with other member states? And another question, will the national antitrust body live up to the OECD recommendations, which are different from the principles of antitrust regulation in the Eurasian Economic Union? Thank you. Well, for the penalties or for fines, harmonizing the... So currently it's not too obvious to me that the antitrust body of Kazakhstan is supposed to scale down its penalty amounts to other countries, listed by the supranational body. Because the administrative policy that is enshrined in the treaty is the policy of compromise. Particularly its checks and balances. This is the outcome. And let's call things what they are. 5 years back, when this whole thing was put together, the treaty, I mean, as long as there is no actual practice of the supranational body's operation, there is the intention to limit its powers and jurisdiction. We still see it 5 years on. So I believe that the supranational level penalties are too small. We will not scale down our fines. Essentially, as I've said in the beginning, if the antitrust body crosses the line or applies something more than soft rules, something more strict than that, when the antitrust body starts using antitrust regulation measures, well, this is a conscientious decision on the part of that antitrust body. This is a finite decision, and, well, it's per se, as they say. So no rules of reason will be heard there. Again, in Kazakhstan, the new administrative code is being put into force. I've met the President of the Supreme Court, haven't studied it myself though. The tools of international treaties and appeals chamber will be introduced. Although we do have a commission, so this work is in progress. As for the amounts of penalties, we do not have a definite or defined position at this point. We believe that the fines are supposed to be severe enough, because if you're using some tools, if you're using antitrust tools, they are supposed to be threatening, they're supposed to be a threat enough so that people would understand that that sword that's in the sheath at this point, if it's raised and if it's raised into the air, it will actually cut off heads. And this sword is the guarantor that the soft regulation will work this way or another. The second question, OECD recommendations. As for Kazakhstan, we have fulfilled them all. Just one more is remaining. Literally yesterday I've been on VC with Antonia Kapobyanka in Paris. Everyone was quite positive about the progress made. I've already given them a different task where so far with participants of the Committee on Competition of the OECD, our mission is to become the member within several years. I mean the Committee on Competition. But there are several things that we still debate on. First and foremost, this is unfair competition. And in principle, we're talking that if it is directed at undefined range of consumers, then these are competitors. If it's related to civil turnover, it's more of a judicial practice, or it should be dealt by our consumer rights protection colleagues. Nonetheless, the practice shows, and I'm gravitating towards this idea more and more. Well, we believe that unfair competition is not really our thing. Unfair competition should be outsourced to legal bodies, so that they should be handling it. Well, the workload, the immensity of these cases is amazing. Antitrust bodies are often become hostages, the victims of, well, mere competitive struggle. So I believe that unfair competition in the near future, well, just to give you an example, the German antitrust, the Ministry of Justice is handling that. The antitrust agency in Bonn is only an indirect stakeholder in this process. So this is my vision according to as to the points, questions that you've raised. The OECD recommendations, well, I'm looking forward to the recommendations OECD will provide to the supranational antitrust body, because this will be the foundation for further amending the law. That's it, I'm done. Thank you so much, Sirik. There are other questions. Unfortunately, we will not be able to voice them at this point. I hope that we're going to try to ask them. If the recipients of these questions stay on until the end, particularly Kirill, he'll definitely be here. Alexei Sushkevich, there's a question to him as well. So should we have question and the speakers are able to stay with us, we'll pass them on. So who will be the true adepts of the competition on the transboundary markets and stay until the end, possibly invading into lunchtime? We will see. Okay, so the first session is exhausted, has been exhausted. I wish to report a significant drawback of online format. We are unable to meet during the coffee break, discuss our conversation over a cup of tasty coffee. Unfortunately, this is the fact of life at this point. I hope you have this opportunity to take an individual coffee break. We'll get back to discussion in, say, 12 p.m. on the dot. So a 12-minute break is announced.
Сергеевич, вы меня слышите?
Уважаемые коллеги, продолжаем нашу секцию.
Respected colleagues, we will continue our activity, and we are limited in terms of time, so we are limited until 1 p.m. Organizers have agreed probably we would stretch ourselves for another 10 minutes that we might be using for questions and answers. So in this respect, please make sure that I would be tough enough speaking the time frame that you are offered. In case you could cut at least 1 minute saving, would be grateful to hear the major elements, but at least to take the floor rather than take part in discussion. So we'll continue our activity. We will give the floor to Laura Baudenbacher, lawyer in the Clear Gottlieb. So new challenges in the EU integration.
Thank you very much, Mr. Chairman, and let me begin by thanking President Bachev for again inviting me this year. I'm delighted to be speaking in front of the legal elite of the Eurasian Economic Union, so thank you very much. I am speaking about, let me just share my screen, about hot topics in EU competition law. And let me just open this. There we go. So this is an overview of the topics I was speaking about. In particular, a focus, as no doubt is also the case in the Eurasian Economic Union, on digital markets and how to apply the traditional tools of competition law to markets that are so fast-changing and innovative and have certain features that differ from traditional markets. So some background on the developments in the EU. There's been an increasing public awareness of the role and the strength of large digital companies, and therefore also a certain pressure on political actors to take action against these companies. 2019, we had European elections, and this brought in a new commission, a new president of the commission, Ursula von der Leyen, and she created a position of the executive vice president for a Europe fit for the digital age, and she appointed Commissioner Vestager, who is the commissioner of competition, to this role in parallel. So that already shows you that there is a focus on this topic. And again, also in 2019, a number of reports were commissioned.
Максим, скажи, а плохо видно на самом деле?
On the question, again, how to apply competition law to these fast-moving markets.
Лаура, пожалуйста, остановитесь на минутку.
Laura, please, could you please stop for a while? You have launched the presentation and we could not see it. Would that be possible to share the screen? Just
yes,
simply, could you please use the function share screen?
It's in presenter mode, please.
Could you switch on regular view, please?
Yeah, please disable the presenter mode.
View. Thank you.
Okay. How do I put? Is
F5 would be okay. Yes.
Is this better? Sorry.
And please increase the sound if possible.
This is better, yes.
The original sound.
Okay, is this better? Can you hear me better and can you see the slides better?
Could you just click F5? F5 would be okay. Thank you.
There you go. Is that better?
Super. Thank you very much.
Perfect. Thank you. So again, in 2019, a number of reports were commissioned on how to address issues identified in the application of competition law in digital markets in the EU, in Germany, in the UK, but also other countries. And following the publication of the analyses in these reports, a number of changes have been proposed to the competition law rules, in particular with a focus on abuse of dominance. So in the EU, this is, and we'll get back to this, the Digital Services Act and the Digital Markets Act, as well as the new competition tool. In Germany, there are currently discussions underway to amend the German Antitrust Act to give the German authority broader powers in enforcing competition rules towards so-called gatekeepers, so very large tech companies. And the UK is also contemplating a code of conduct for such firms. So as I mentioned in a bit more detail, the European Commission this year launched a consultation where stakeholders were asked to provide their views on the creation of so-called ex-ante rules, which will, at the moment, the vision is to create a so-called blacklist, a set of behavior rules that would be prohibited for companies that are dominant in these digital spaces. The European Commission is also creating a new competition tool. This will likely be a type of market analysis investigation tool, which will allow the Commission to monitor and analyze these types of markets more efficiently. The United Kingdom as well is considering a type of code of conduct and will actually now also create a digital markets unit to focus more on the space. But the largest changes, I think, are pending in Germany, where currently the 10th amendment to the Act Against Restraints of Competition is being discussed. And it, if passed, it will bring very sweeping changes to the regime in Germany. First and foremost, it introduces a new concept that goes beyond just the classic dominance approach, where a firm is considered dominant on a market because it has a large amount of a high market share. Here, the German legislature is introducing a so-called superior cross-market power. And this type of cross-market power would be found for companies that are dominant in one or more markets. They have significant financial resources and they have access to the necessary inputs. They're also vertically integrated, or they have a strong activity across several markets. Of course, access to competitively relevant data is one key element here as well, and their relevance for third-party access to the market. And when a company is found to hold such a power, there will be in the future quite strict behavioral rules as to self-preferencing, for instance, for a search machine operator, how to display their own offers in their own search machine, for a social media platform operator, whether they can bundle or tie their offerings on other services. An example here would be Facebook, which offers also WhatsApp and then ties the data. So it's going to be very interesting to see how this is applied, because some of these conducts are while understandable that the legislature wants to regulate them, are actually quite new and give very, very broad powers to the authority. So we will see how this will be applied as well. Also, the dominance framework, the traditional one, will be expanded in the sense that access to data will become an element in the analysis of a company's dominant position. and I will leave you, the rest is details, I'll leave this to read to you. The concern about positions of digital companies has also shaped merger control, because traditionally merger control is based on the approach that authorities have the power to review transactions where the companies exceed a certain turnover threshold. That is more or less the dominant regime throughout the world. And so the concern has been that large pharmaceutical and tech companies buy smaller competitors as in so-called killer acquisitions to inhibit competition from small innovative players. And the concern here is that some transactions such as the purchase of WhatsApp by Facebook or Skype by Microsoft or YouTube by Google, these are all large names, large companies, but they have no turnover because many of the services, WhatsApp is, for instance, offered for free, so it doesn't generate revenue in a traditional sense. And these transactions were not reviewed by regulators, obviously, because the target did not meet the necessary thresholds. So the concern here has been a bit how to shape merger control in a way that allows the regulators to review mergers even absent the thresholds or the turnover of the target. And so there's been a lot of discussion around introducing so-called value-based thresholds, and I'll get back to that in a second. Germany and Austria have done so. They have amended their competition law to introduce such value-based thresholds. There was discussion on European level for some time to follow the German and Austrian example. However, just now in September at a conference, Commissioner Vestager announced that they would not perform a major overhaul of the EU merger regime, but they would rather fine-tune certain elements. So there will be no new value-based thresholds, but, and this is going to be interesting, the Commission is launching will launch a consultation on this, on how it is declared that it will change its practice in referrals from member states. So as a quick background, member state authorities have the possibility to refer cases to the European Commission where they deem the European Commission better placed for whatever reasons to investigate the case. And until now, the practice has always been from the European Commission and by the national authorities as well, obviously, to only accept referrals or to only refer cases where the national authority actually has the competence to review the case. So if the thresholds were met on a national level and the national competition authority was competent to review the merger, it had the option, if it wanted to refer it to the European Commission. And the Commission now wants to expand this to cases that the national authorities could refer, even if on a national level they do not have the power to review the case. So that's going to be quite interesting to see how these rules are shaped. I think there are concerns over legal certainty that will definitely need to be addressed here. Otherwise, it will be very difficult for companies to understand in which situations they can be involved in a EU merger proceeding. The Commission has also announced a simplification of its merger review process, which personally, after just having come out of a year-long, very, very complicated pre-notification discussions in a case that is not really in itself competitively complicated, I think any practitioner would welcome this. This has been, in the past years, has been quite, has been expanding increasingly, and pre-notification now typically takes several months. and causing, well, some frustration or also just delays on the company's side. So I think that's definitely a step that would be welcomed. And Vestager also announced that the Commission would review how it assesses cases on a substantive level, and especially in light of more digitalization and in certain European industries also a high degree of concentration, in particular, for instance, the telecom sector. However, there is the appeal of the Commission pending before the European Court of Justice in the CK Telecoms case, where the General Court found took quite some issue with the Commission's merger review in that case. So I think that we will only see steps in this point once we have a final ruling from the CJEU. Again, as I mentioned, just quickly, the Germans introduced a so-called value-based threshold, the Austrians a similar one with a slightly lower threshold, and you can see here that is quite low. Limb number 2, 25 million, and neither the target nor any other has a turnover that exceeds 5 million. There was concern initially that would catch a large number of transactions. To a certain degree, this has happened, which is why there is now discussions underway to increase this second limb thresholds to weed out the smaller cases. The new test also introduced a local nexus test, which, moving on to the next slide, was something that has been a bit of a tricky element for practitioners, because what does it mean having a local nexus? And in particular, in our modern times, when, as a digital company, do you have a local nexus? Digital companies operate all over the world with a headquarters somewhere, and establishing that local nexus to Germany can be quite tricky. Both the German and the Austrian authority published a joint guidance paper, which gives some more clarity, especially on the significant domestic activity limb, in explaining to companies when they might be considered to have such a local nexus. Now, my final point, and this is, I think, something that we might be discussing in next year, but my impression or my outlook of what direction competition law is going, my impression is that we tend to see it a little bit as a cure for issues that are outside of the scope of competition law, and there are attempts to broaden the application of competition law. So, for instance, in the UK, there has been a call to shift the analysis of the UK authority away from the traditional approach of looking at harm to competition, which is quite broad, which involves everyone, suppliers, consumers, all sides of the market, to an adverse effect on consumers, which would be a quite significant change in approach and analysis. Not sure whether that will go through, but a very, very interesting step nonetheless. The CMA is now also potentially considering introducing a mandatory merger review regime, where previously in the UK, or to date currently, there is a voluntary merger control regime that would change things quite significantly, also in light of Brexit, which would mean that companies now need to notify also in the UK. It wouldn't be sufficient to just notify with the European Commission and cover then all the EU member states. In Germany, we have seen attempts to use competition law to enforce data protection rules. There was the famous Facebook case in which an abuse of a dominant position was found inter alia because of the allegation that Facebook violated the EU GDPR in the way it collected data through Facebook.com, but also combined it with data collected on WhatsApp. Especially last year, it was quite an attempt on the political side to influence or shape competition law. Commissioner Vestager was under a significant political pressure, especially from Germany and France, to allow the Siemens-Alstom rail merger, which was ultimately prohibited and which led to a push from Germany and France to overhaul the EU merger control rules to enable the creation of so-called national champions. And let's say the underlying goal here is quite protectionist or quite nationalistic, in the sense that the argument has been we need to be able to create large companies that can compete with big state-owned Chinese competitors. So far, the Commission has resisted these attempts, but it was quite an interesting time to see so much fascination from the political side and interest in competition law and merger review. And finally, I think a big topic that we will be addressing more and more in the coming years is how to align competition law with sustainability goals and environmental protection. There is a balance to strike between enforcing competition rules, ensuring fair competition, and avoiding illegal information exchanges, but also at the same time allowing the industries that are relevant to the climate discussion to create solutions jointly that would, be more sustainable, more beneficial to the environment. And striking that balance, I think, will be a large challenge for regulators and legislators in the coming years. So that concludes my presentation. Thank you very much for your attention and questions.
Thanks very much indeed, Laura. It was a very interesting presentation. It was very interesting to hear you. I doubt there would be time to have questions because we are outside the schedule. Once again, I would kindly ask all speakers to adhere the time frame. I have not been interfering with the lady, so I was not asking her to accelerate or speak up. But I would ask Alexei, next speaker, with all due respect to you, make sure that you keep with the time frame 10 minutes, not more. So simply we are framed by the organizer of the conference because of the equipment need. It's unlikely that we'll be switching to questions and answer sessions. So to make sure that floor is given to people that have applied for the floor.
Good afternoon, Denis, colleagues. I'm very thrilled about this opportunity. Very thrilled about this opportunity. Hopefully we'll get to see each other live soon. So let me start with bringing my slides to everyone, right? So you should be able to see it now. Not exactly full screen, but there we go. So, dear colleagues, let me speak in a nutshell about the outcomes of the work, of the progress being recently made for the Eurasian Economic Commission. Particularly, Mr. Sushkevich has been able to see this presentation, has been able to read up on these facts, but I hope that for a broader audience these aspects will be interesting. I'll try not to reiterate or not to repeat what the previous speakers have said. I've been following this from the beginning, so I would just like to reflect practical points for my colleagues, particularly those working in judges. So indeed, competitive policy is very important. It's the Eurasian Economic Commission is also preparing this. The digital agenda, coordinated and approved by the heads of the state, has a lot of movements and progress there. However, in antitrust regulation, Well, several steps ahead could have been made by way of adapting the requirements of antitrust regulation to digital economy. The previous speaker has outlined marvelously the tendencies that we observe in Europe. It is not the right time for us to lag back, to lag behind. So sometimes we start on something very actively, then we abandon it, and by the time we get back and resume this activity, everyone has made much more significant progress. Everyone else has. So the antitrust package discussed by Russia has already been implemented in Germany. So 2018 we've outlined the basics, but 2 years have been wasted. These provisions were traveling from office to office in search of approval, and ultimately, well, the German 10th antitrust package, I see blocks of Russian work on the same topic. So, well, this is a happy moment, but on the on the one hand, but on the other, it's a sad bit because we ourselves fell short of implementing it. So, digital economy, what kind of requirements does it impose? Business models have changed. Approaches to organization of the markets have changed. The key markets in this, the key players in these markets are those occupying a special role in the contemporary digital economy. As organizers of digital platforms, ecosystems. No stopping there for too long, but the key parameters is the control over big data, is a special strategic standing with respect to a whole number of adjacent markets. Because the role of these giants is not just industrial players, these are organizers, these are the ones calling the shots basically. They organize in a new way, it's a brand new challenges to antitrust bodies. Another serious challenge is how many businesses implement algorithms in their activities. Algorithms accelerating the price adaptation, getting the prices closer, thereby they affect the logic of the demand and supply of law. We know that the pricing is changing very strongly in the capitalistic system. If previously in the industrial economy we could clearly understand that through price and the hypothetical monopoly testing and other methodologies worked quite well. Through price we can assess the elasticity of demand. We can see the correlation of the supply and demand according to this market law. Now that there are digital algorithms involved, milliseconds, nanoseconds that it takes to sync up prices of multiple platforms, implementation of mechanisms of perfect price discrimination, where price proposal is correlating on many parameters, including the behavioral patterns of that particular group of users, a group of consumers. It's kind of a profiling of users leveraging the personal data that platforms collect. All this twists pricing and it messes with the supply and demand law. These conclusions from our small-scale research have shown us a number of pain points, potential bottlenecks, where antitrust bodies, be that Eurasian Committee or national ones, these pain points should be on their radar. This is my subjective expert opinion. I believe there's a lot of progress to be made there. I'm convinced there will be applications filed to the Commission along these vectors, along these directions, and there is every prerequisite to say so. These issues are arising strongly in the European Commission's activities. They're dealing with it heavily. Also, based on our research, we know that there is a lot of demand for that by businesses, on the part of businesses. Let me skip foreign experience for the sake of time saving, because the previous colleague Laura did elaborate in detail on the European experience. The innovations and the novelties that we see in Germany, I'll reiterate, they were offered in the fifth package of antitrust measures. They were lost to bureaucracy, but let's ignore the sad bit for a moment. I know that I have 5 minute stops, right? Somebody complains of the audibility, but it seems to be fine.
Все хорошо, Алексей Юрьевич, спасибо.
No, everything is great. Everything is great. Okay, anyway, so I seem to have around 5 minutes. Sometimes the problems are not on the speaker side. Maybe the listeners. Okay, geo-blocking. Somewhere Zoom is geo-blocking the sound, possibly. And the colleagues are having a hard time hearing me. Okay, so the European Commission has dealt with that. The essence of the discussion is quite simple. We're building this harmonized space. Digital single market is the way it's called in Europe. In our reality, the Eurasian Economic Union, there is nothing of that sort in principle. So we're facing this problem where a number of services that operate in the territories of Eurasian Union, they act or they operate differently in different countries. Say a consumer offers, a consumer accepts an offer for some digital service. The Oka cinema, online cinema that operates in Russia and Kazakhstan, we did control purchases of their services. In Kyrgyzstan and Armenia, this service is less available, or is available with limitations. So that's a problem. That's profiling, geo-blocking. The European Union has faced this and dealt with this. I hope that there will be enough applications from consumers, from competitors, that will help the European Commission to the Eurasian Commission to advocate the interests of the development of the Eurasian market and to use antitrust tools, because we are convinced there are serious grounds to launch a full-fledged investigation of antitrust nature. We will use the leverage available to us, the tools available to us, to ensure this antitrust practice is seized. So Alexei mentioned the Cochlear case where a foreign company was using its distributors through the special mechanism of coordinating their activity and collusion between these distributors in the Eurasian Economic Union countries. They completely distorted the market dynamics for shipping these cochlear implants. So we believe, we see the issue of these collusions growing even stronger and more wide scale, because there are tacit collusions which are very difficult to identify, because the algorithms classify data, special communication algorithms are used, they're uncatchable. Price parity requirements, price parity clauses, this is something that helps platforms kill in the bud, kill the competition in the bud. So they accumulate market power, they increase their dominance. There is a discussion as to how to interpret this provision, but there are issues there, clearly. And the focus of antitrust bodies should be there. The European experience, global experience tells us that this problem is long overdue. Resale pricing. You have 1 minute. You have 1 minute. Okay, accelerating, skipping the uninteresting parts, going to the juicy bits. So search market. Well, the slide seems to be stuck on one slide, the slideshow. So there is a practice of bigger players squeezing the smaller players out of the market, representing various segments, ticket sales, ordering various kinds of products, video streaming services, marketplaces, and so on and so forth. Smaller players are squeezed out of these markets. There is a serious pressure against these minor players, which are heavily represented in the platform of Eurasian Economic Union. The giants, typically Google and Yandex, are suppressing the small local ones. We're talking about the specialized enriched search output, also search results, and that the said two platforms are using to increase their power in the adjacent markets. So this is the sorcerer, this surf feature. This sorcerer, the wizard of Yandex looks like. They prioritize the search output, the search feed, to boost their services, to promote their own services. So let me skip to the end. We see this one systemic flaw in this situation. The intra-platform competition in Yandex and platform is strongly distorted. And those special obligations that the German government is putting forward in the 10th antitrust package, those obligations that were identified by the EC in the Google case for vertical search, the judgment was passed. These obligations are not implemented in the Eurasian Economic Union. Moreover, we have a Russian case against Yandex by Prompt company lawsuit. This case has already been considered by the Court of Arbitration in Moscow, where the court quite cynically formulated what the Prompt company that does machine translation and is being displaced by Yandex because of this enriched search feed mechanisms, tools, through specialized privileged services that Yandex services get. There was a very cynical response from the court. Prompt, please go ahead and build your own search system. So this is not the answer, dear colleagues. If we respond to the digital economy challenges these days, when smaller players, smaller companies that are heavily represented, like I said, in the digital economy sector in our countries, when they raise a question, they say, guys, we're being squeezed out from a specific platform. We're deprived of the possibility to advertise our services in a proper way. We cannot position ourselves, and they get this, create your own digital platform and compete using it. Thereby, we simply kill these alternative services possibility to develop in the budding. So this is a very bad problem. The Yandex v. Google case by the Federal Antitrust Service of Russia, Yandex did not mind that the Android platform that was Google, owned by Google, it discriminated against Yandex. But then the point of Google, the argument of Google, please Yandex, go ahead and create your own mobile OS, it was not taken into account by the regulator. Yandex is using a different argument. They're using, so now the Yandex is basically abusing the kind of argument that it suffered from back in the day. And the final bit is the intellectual property, IP. That's a big problem that we're all facing. You know that the standards in the technological standards, in the digital economy, industrial standards, sectoral standards, is a very important parameter through which, in part, monopolization of markets is going on. So in our case, most jurisdictions in the Eurasian Economic Union, with the exception of Kazakhstan, that thanks to the OECD recommendations in part, was able to discard this harness. They have this yoke. So others cannot simply apply these recommendations. We have created our own legislative bodies immunity to antitrust recommendations. Not a single sane or reasonable jurisdiction does that. But we've done it for ourselves. The Russian Federation has a big advantage, a big upside on that. We don't have this kind of immunity. We did not create it. So the abuse of intellectual property is possible elsewhere in the customs union. As for the technical regulations linking patent rights and standards, there's a huge area for activity. However, to that end, one of the most important matters is, again, going away from this extraterritoriality ban, the impossibility to apply EAEU legislation, EAEU law to third parties, so companies headquartered in third countries. So this definitely curtails the powers of the Commission. You know, Denis, I have a whole bunch of recommendations to be dwelled on here. Yes, but I'll wrap up here. Because, well, there's no way you can end, you can finish refurbishing your place. You can only suspend it for a while and then resume. So here's hoping that we'll get to see each other again soon. Yes, very much, very interesting. Thank you very much. Now the floor goes to Mr. Melchenia, advisor to the court, to the judge of the Eurasian Economic Union Court. Please, Yulia, can you be brief? Because we have one person under threat. Evgeny Tariba might not have the time to voice his presentation, but we will try to squeeze all the speakers in and give some time at least to him. So 7 minutes to all the next speakers. Yulia, the floor is yours.
Okay, thanks very much indeed, dear colleagues. I'm going to launch the presentation. Well, I would like to pay attention to a number of aspects related to state procurement. In particular, first I want to comment is a national regime which is ensuring at the level of the treaty of the Eurasian Economic Union. So that based on national regime, that means and refers that goods, potential participants, member states are given the most favored regime on compared to goods, commodities, services of other countries. So in order to confirm the national regime, a lot of work is conducted by the Commission that Arman was mentioning. It's actually the development of rule of proving the country of origin within the framework of the EAEU. At the same time, national regime of declaration have to be respected and ensured by the member states. At Protocol 25, Annex 25, is 25th annex to the treaty, envisages opportunity to establish exemptions and limitations according to the national legislation in exclusive cases for purposes of confidentiality of information. As exceptional cases could be member state at the level of the union, not more than 2 years. And then today we see the practice of the member states that in a number of countries expressed in the following way, that at the history of union, during the history of existence of the union, so there have been exceptions, exemptions installed. So there has been a reason to approach the Eurasian Economic Commission to the court of the EAEU on explaining the law of the union, whether the limitations and exemptions can be established a number of times, or the norm is just one time. As it seems to me that exemption and limitations should be considered not from the point of view of the rule of setting up or establishing. So within the framework of the activities conducted by the Commission in establishing the exemptions and limitations, in fact the Commission exercises ex ante control. When they establish the specific features of exemption, they evaluate, the Commission evaluates the participants, member states participate, to what extent in this respect, this kind of exemptions and limitations are established, but at the same time, in a more efficient way, we see the practice that could be traced within the framework of implementation of the state procurement at the WTO. So the committee exercise ex post control. That means when they evaluate efficiency of exemption of the national regime, for the commodity, the developing state, if they believe necessary, would be entitled to introduce while joining to such agreement. Seems to be that the court would give an answer in an advisory opinion, and the existing practice of the states would be improved. So the second issue I'd like to pay attention in the context of the state procurement, as well as it is related and does take place, and the exemptions and limitations. So there are obstacles at the local market, like barriers. Again, limitations or exemptions. The four areas or four types for the state procurement. Victor was quite right mentioning on Wednesday presentation, one barrier is eliminated, the second emerges. Before the first appeared in September, so there were four of them in the state procurement. So that's, and don't have one barrier, we eliminate one barrier, another appears. But the problem that exists and they prevent from the generation of common market in the EAEU is the digital one. is the problem of electronic digital signature recognition, because actual situation is it's recognized only between the electronic trading areas of the Russian Federation and Belarus. In relation to other states, the work is underway. The plans of activities for mutual recognition are adopted, but we see that for the time being, in order to participate in such procedures, one was supposed to become a resident of other country. There are certain administrative barriers that results in costs, extra costs, loss of time, etc. In relation to the last barrier or limitation related with possibility to recognize banking guarantee that would secure implementation of obligations and meeting obligations, I would like to point at the Commission's decision. So, because the reason of this was legislation of the Russian Federation in April 2020, it was adjusted, changed. Therefore, in September 2020, at the level of the Council of the Commission decision, it was suggested to launch a pilot project on mutual recognition of the mutual banking guarantees that are issued by the member states. As the activity was underway, this limitation would be eliminated. So working out the issue or developing the issue so that this kind of guarantees are recognized by Eurasian Bank of Development for the entities participating in state procurement seems to be the key obstacle. I need to mention that electronic format is used by this or that member state, so that means the procedure are digitized. So one of the directions that one may think of is development of a common digital market for the sphere of state procurement, like a portal in the sphere of the EAEU that would reflect all information, current information on procurement. In case this barrier is eliminated, that is related to electronic digital signature, there would be no barrier environment created, and information would be freely shared. So they will have full information what kind of procurement are done by which country, and then they would decide whether this would be expedient to take part. Thank you for your attention. That's all I wanted to say. Thank you very much indeed, Yulia, for the interesting presentation, for the analysis of barriers and limitations of the state procurement in the Eurasian Economic Union. It was started in my reservation in my the last decision on competition law. I think it would be continued. Thank you for organizing, analyzing our future consultative advisory opinion. The floor is given to Ivan Starikov, lawyer of Antitrust Advisory. Ivan is yours. The floor is yours. Please make sure that 7 minutes. So please cut down. And then we will give the floor to Ivan Voznesensky as moderator. I'm going to share with both of you my responsibility to Evgeny Tariba, so to make sure it's not my sole liability, but I hope we will keep the 7 minutes frame. Colleagues, very good afternoon. From the point of view of a lawyer who is working in the sphere of practical application of the law, the troubles and issues that might arise in the Eurasian Economic Commission practice when it would be entitled to issue warning. So the issue is multiple qualification of the abuse of dominant power. So probably the economic entity might act or might be subject to a number of abuses of the dominance. And it would be necessary to see whether this composition of the violation, as we see from the treaty of the EAEU, so this is abuse of domination, abuse of monopoly low price. The limitation is not which way the Commission should act. Whether they should issue warning and they allocate deadline to implement it, or the Commission would issue warning at the same time start investigation on the revealing of the content of abuse. There is no direct answer in the amendments to the EAEU treaty, but it seems from the logic and the common sense that the Commission should limit itself to issue the warning, establish the reasonable deadline, and expect until the warning is implemented. So, secondly, if the acting entity has been found guilty or has been warned by the Commission, and again actions are considered that should result in warning. But from the time the previous warning was issued is less than 2 years, 24 months. The Commission would not be able to do so and would not be entitled, and the Commission would have to launch investigation. I wonder the rules are established, whether they offer presumption. The very fact that the economic entity was warned previously makes it impossible that this kind of soft measure of influence like warning is applied. Therefore, it would be logical to ask a question whether this kind of warning is issued, then what kind of importance would be execution by the economic entity of this warning, or following this warning, requirement of the warning, so that there would be consent and recognition of the economic entity that the action were resulting in abuse and it has taken place. If we agree with this kind of approach and we believe that warning compliance is recognition of the fact of abuse, that means that a party suffered or the consumer will have a simplified opportunity to recover damages. So within the framework of collective claims. Next question, related to warning, it is standard of proof. What would be the number of features of violation and which features of violation should be established that the Commission would be entitled to issue grounded warning? In relation to practice of national anti-monopoly bodies, to issue warning, there is a simplified standard of proof. Let me disagree with this. And I would suggest the following rule. So to issue warning, one has established a number of features of violation that would have been needed to start investigation in a normal situation. That issue of warning is not needed. It would be quite logical, because if warning is issued and then economic entity fails to comply with it, then next stage and next warning would be next stage. The Commission would be start investigation, launch investigation. So you need to collect necessary features of this or that kind of violation in the activity of the economic entity. Certain elements of the violation of, for example, unfair competition would mean and refer establishing specific features, specific characteristics in actions of the economic entities. So issuance of warning is impossible. For example, last year the Supreme Court of the Russian Federation recognized illegal warning of the Federal Anti-Monopoly Service of Russia that was issued to the economic entity that was selling tobacco items in violation of the anti-tobacco. It was closer than 100 meters to the educational institution. Anti-monopoly body considered that they have received advantage compared to their competitors because they have not been entitled or able to carry out their economic activity within the range. Anti-monopoly court disagreed. It was unjustified and ungrounded because it was just an assumption of the anti-monopoly body and there was no real proof of anti-competitive actions have taken place. That would definitely enable the economic entity to receive certain privileges, certain advantages, but unfair behavior and direction aimed at obtaining advantages have not been established. Next is whether the company to be warned are able to look at material after they received warning that warning was based on. At present, this issue is not regulated, but it seems to be that it's very important guarantee of protection of rights and interests of the economic entity, so the guarantee that ungrounded warning is issued. One more issue is where when action that were considered violation have been stopped. in the practice of anti-monopoly bodies in a specific country are present. So the principles of action that have been stopped, and the Commission is faced with the question, what is to be done with this kind of cases? Then the Commission will have to answer two questions: whether the warning can be issued in case action is completed, or whether the case could be initiated where it is impossible to issue warning. So that there are features already revealed that were resulting in violation. Seems to be that current wording of the treaty of the EAEU is negative. The Commission doesn't have powers like this. They are not envisaged. Unfortunately, violation may be left unpunished. At least current wording of the treaty does not allow to arrive at the conclusion that the Commission is entitled to act like this. In practical, anti-monopoly service of the Russian Federation follows the appropriate approach. Case cannot be initiated if the action is stopped or warning is issued. But they make use of this kind of tool, so they could refer bypass when warning is issued and it is required to eliminate the consequences and the reasons of violation. This mechanism often allows anti-monopoly service to act for activities that have been done in the previous days and were over, stopped so that the case is initiated. And the last question, whether the economic entity that has received warning to persuade the Commission so that there were no features of violation in their actions. Whether they would be able to present additional explanations and proofs and persuade the Commission that the investigation should not be launched. Based on the explanation of Federal Anti-Monopoly Service, this kind of approach is possible. Which would be actions of the Commission, we don't know, but we want to believe that the Commission would adopt this kind of approach. Thank you for your attention, colleagues. Thank you, Ivan, for raising these important issues to us, and then you tried to forecast possible answers. But life will show which way the Commission would follow. Nikolai Voznesensky, the floor is yours. Please make sure that you keep within the framework of 7 minutes.
Yes, thank you very much, Denis. I wish to thank the hosts of the conference for the opportunity to speak. My presentation will be dealing with geographic and product boundaries establishment. So, first of all, the geographic ones. The topic is quite well known by experts, or two experts. However, given the two-tier nature of control bodies in the Eurasian Union, well, it's gaining more complexity. And we've seen how important and how challenging this topic is, exemplified by the Delrus case, the board, judgment 65 of the Eurasian Economic Commission. So how did the geographic boundaries matter influence that? First of all, is the competence of the board of the chamber of the Commission to consider this case. Transboundary, check. So it has been it was in power. So spanning over 2 or more member states, territorially. Second point for correct border delineation is market analysis. Again, this is part of the case. And the third aspect in Judgment 65 was the essence of the violation, because it was assumed with the alleged violation was lack of coordination between competing companies. Part 3, Article 76. Lack of coordination depends on the markets where companies operate. In that case, every company was working in Russian Federation, Kazakhstan, 2 companies respectively, and defining this market as transboundary made these companies competitors in the markets of Russian Federation, Republic of Kazakhstan. But the fact that the geographic markets, if we were to proceed from the geographic boundaries viewpoint, these companies would not have been deemed competitors. So these are the three aspects where geographic boundaries are important. So question number one, the important question. The methodology of assessing competition, there is Article 26, Para 26, territorial nature of the markets. Transboundary nature arises where a company is shipping goods or services from one member state to another member state, or to the territory of the Eurasian country from third countries. The considered case, the Belarus case, was not eligible to that because each company operated in their own respective country. The board or the chamber of the EEC positioned the following task. So if there is territorial delimitation, when possibly the goods are not shipped from one country, from that country's company to another country because there was an agreement. This was a very narrow market servicing a specific type of medical equipment. It's a very niche and very specialized market, very small one. So the activity of main players basically predetermined lack or actual supplies from services from one country to the other. So the question was whether the company or whether the Commission should use or not use the Article 26. The court at the first instance resolved that the opportunity to ship a product or service is enough to deem the market transboundary, but there were two minority reports from the judges. One of them ran the disagreement to set such parameters for a particular item of violation, particularly violating Article 26, is the new norm, where in some violations, for some violations, the competitive analysis will not be used for this particular case. So this is a legal challenge. The possibility or the obligation or lack of obligation to hold an economic operator liable because of the violation of Item 26. Another more important point raised by the Chamber, what is primary? Creation of the conditions for the single market of the Union, basically lifting the barriers by member states, and then request to the companies to act as if the market is single and transboundary in nature, by nature, or primarily, or its primary is the behavior of the companies that are supposed themselves to tackle the multiple barriers that exist in the way. So what am I talking about here? The servicing of the medical equipment that I've mentioned requires licensing. This is servicing medical equipment. It's such regulation, licensing exists both in the Russian Federation and in the Eurasian Economic Union. There is an exception if licensing is required by the Russian Federation, so only a Russian entity can engage in this kind of activity. That means that the Kazakh entity cannot render such services, licensable services, in Russia, whereas a Russian company can do that for the for Kazakhstan, because Kazakhstan does not license this activity. This is an obvious barrier. This is an apparent barrier recognized at the legal level. The companies claimed that their activity related to the limitation. You have 1 minute. Okay, so the limitation of geographic operation to Kazakhstan alone is caused by this constraint. Yulia and Eudenis, in your presentation, you have mentioned that participation in e-procurement requires the recognition of digital signature. So this was also observed in this case because there was a complaint when a Russian company was not participating in the relevant state public procurement, and the company, again, this barrier was used as an excuse for one company not to be participating in the market. So if these barriers are enshrined in the domestic law and in the Eurasian law, should the companies bear responsibility that if they're unable to overcome some barriers through economic or other reasons, they were precluded from acting in a specific market? The nuance, the peculiar feature here is that the agreement was decided on, whether there was agreement or not, was indirect signs, indirect symptoms. So this is a second legal point, so the country of operation and the country of origin. This should be resolved. And I believe that considering three special minority reports by three judges that raised the point, that raised the issue of geographic boundary delineation, well, this requires further special focus to these matters. I believe that the Chamber of the EEC and the Court of the Eurasian Economic Union will handle this appropriately in the future. Thank you very much for your attention. Thank you for your talk. So, based on the decisions from the Chamber of Appeals Chamber, we have literally 5 minutes to give to Evgeny Tariba.
Evgeny, we were really doubtful, and so you have 5 minutes to go. Good afternoon, dear colleagues. You hear me loud and clear? Well, I would like to start that in the course of the previous conference, the Kazakhstan presenter was taking the floor and then described the situation, offering a good example of doubtful from the point of view of respect to and compliance with competition rules. So describe the situation that has arisen in one of the regions of the Russian Federation, the Vologda region. The government of Vologod region resolved and decided that there's regional plan to ensure the state order, and then the real Vologda products. So the system of voluntary certification of the real Vologda project that was established for registered under Russian register were not available and possible for the producers outside Vologda region. If you look at the situation from the point of view of the Annex number 28 to the Treaty of the EAEU, this example of the Vologda might be subject to so-called banned industrial subsidies. And then the question arises whether the competition is violated due to regulatory framework documents adopted by the state. So the state sanctions this kind of violation or creates prerequisites for that. In the treaty itself, it is referred to that it is intolerable that preferences of municipal or state level are not allowed. Using this kind of preferences, the mechanisms are limited. So it's normally the offering the state property or other objects of the civil legislation, this complaining exhaustive list. But the problem is not limited to this kind of issues. Then the problem becomes wider of the incompliance of the state bodies adopting regulatory framework violating the competition. What kind of protection mechanisms do exist at the level of the national law? It is clear that the situation that was described with the Vologda product might become the subject of consideration of the EAEU court following the appropriate initiative. It's important to consider efforts of the national courts might take while checking or inspecting, following, of course, the application of the parties concerned of the regulatory framework documents. Here, we need to analyze what kind of remedy can be used, whether the justice bodies can help. If you look at the practice of the Supreme Court, then Supreme Court refers to the Code of Administrative Production. There's a plenary meeting conclusion of number 58, dated 2018, criteria of formal and if we speak about content, if we speak about the lacuna and then uncertainty of this entity that is being inspected and then compliance with the requirement of the existing enforced act, say federal law on protection of competition. And here we could see that indeed Supreme Court can be efficiently involved in resolving this kind of issues when these bans or prohibitions that are referred violations as violation are worded specifically, not described in a general way, like creation of discrimination, or when the regulatory framework document or act orients to have certain goods to be procured, to be bought. When we think about abstract violations, more often Supreme Court refers or states that it is mentioned that it's whether this is economically expedient or not to adopt this or that regulatory framework document. Then Constitutional Court as well takes decisions of this kind, limits itself to the indication that economic expediency of this or that regulatory framework document is outside of the scope of competence in terms of verification or investigation. This is in relation to application to the Constitutional Court. I'm not going to repeat and voice all of them, but what I wanted to say, really not in a nutshell, I'd like to say that in such situations, at least one has to understand the difficulty with qualification and referral to certain market advantages related to the courts are related to two issues the courts are faced with. They're looking for the norm that is restrictive or banning, so that would rely on specific measure of protection or support to the economic entities. And the second reason is risk of going outside the evaluation of expediency that is established by the disputed act. First reason, in my understanding, should be overcome, in my understanding, because without this, without the application of this, with the whole abstract approach to norms and practices, there is no efficiency, and basically that ceases to be applied. I mean, because this would be the norm of law that is banning or prohibiting or limiting competition. Creation of the advantage at the market is not feasible for this or that subject, or a group of the economic entities. So therefore, refusal of the analysis of this measure, whether the criteria of feasibility is inspected, checked or not, it makes difficult to the combat of the violation or incompliance with the competition law by adopting regulatory framework documents. If we speak about limitation, if we speak about requirements on the court repealing the regulatory framework documents adopted, we need to look at the arguments of the applicants and then offer arguments to justify this kind of decisions without limiting ourselves to formal reference to acts. Otherwise, the function of jurisdiction and role in the sphere of protection of competition would be going down, would be diminished. So in a nutshell, that's all that was I wanted to speak about, and then thank you for your attention. Thank you, Evgeny. We almost fit in the time frame, almost, because roughly speaking we are outside already, so waving, somebody is waving, but at the same time I'd like to say a couple of words, because we are concluding not only the session, we are concluding the conference in general. Having faced the tough choice of moderator to continue discussion or to give the floor to the speakers, so I was proceeding that everyone that was willing to take the floor were able, leaving its digital trace where at YouTube channel, where it will be, when we'll come back in a calm mode to listen it once again, to look at the presentations. Alexei stated that not everyone was able to see his presentation, as it was mentioned, so he is going to send it to us. We will place it at the website of the court, probably where the reference to the conference materials would be made available. Everybody would be able to read it. So it was close to impossible for him to demonstrate it, to show it. Would like to express gratitude to all partners to our conference that have been assisting us. Major partner was company Eurspector Limited Liability Company. It's not the first year that we have been cooperating with this. All conferences have been organized, and we hope we would be We would like to express all participants of the conference following the request of the chairperson of the court, representative of scientific society, lawyers, representative of commission, secretariat and judges that were very active in participating. Thanks very much indeed to all of you for your active participation and creative, interesting presentations. Unfortunately, all good things tend to end. So high time to close our conference. Thank you very much indeed, and we hope that we will be meeting in the future within the format of our conference, of annual conference of the EAEU Court, as well as other forum. Thanks very much indeed. All the best.